up in the answer or the presentation materials a little later on in the presentation this morning. This webinar certainly is not intended to be a tutorial on how to navigate a meeting on Zoom or some other virtual reality type browser. That whole process and how to do that and conduct and I'll do a lot of that stuff is new to me as it is, I'm sure, to many of you. There are a lot of great YouTube videos and things for you to do that. I also encourage you, if you're going to have a meeting or participate in a meeting, you can log on to most of the virtual browsers and get a free membership for a period of time. I encourage you to set up your own meeting, get in, play around with the format, try all the different icons, see what they do, and become a little bit more efficient on that. And certainly if you're an administrator or a board chair and you're going to be doing a meeting, you can always have a mock meeting or something in advance to kind of allow people the opportunity to learn how to interact with that in a more informal setting. I know sometimes when we actually have a meeting, it's a little difficult to really get into a lot of those technical issues, so don't hesitate to do that. I do have some tips and pointers, some navigation tools that I certainly will go through today. Today is a Zoom webinar. It's a little different than a Zoom meeting, so some of the functionality that exists in a Zoom meeting is different, and I'll go through those. First, in a webinar, the groups are divided between participants and panelists. Obviously, in a Zoom meeting, it's host and participants. As a participant in a webinar, your video is off. We do not have the ability to turn it on unless we make you a host. So if you're sitting at home in your pajamas, drinking a cup of coffee, by all means, you don't have to worry that somehow we can pull up. I'd love to look around the room and find out who's sleeping on me this morning. That's going to be a little difficult to do. So relax, kick back, and enjoy your morning coffee. You have very little control over what you can see on your screen. You should have, and you do have, my PowerPoint slide and a picture of me. If the picture of me is any bigger than a 1 by 2 inch square, you need to shrink that down and increase the size of the slide so we can go through those. You can do that by, if you look at a bar next to the picture, you can drag that back and forth. It's a long line, or next to the icon, there's some options there for you as well. So, in a Zoom meeting, there is typically an icon for chat. We'll talk about how to use that in an open meeting. In a webinar, there's both a chat button and, as I indicated, a Q&A. So we want to be able to make a distinction. You can certainly chat amongst yourselves a little bit back and forth, as you often do through my presentations, by using the chat and directing where that goes. Typically in a webinar as well, there's very often a hand up that you can literally, click on that and it will demonstrate that someone has raised their hand. That's really helpful in your open meetings and in a meeting format, so that individuals who have a question that have been silenced or are members of the public and you have them on mute, not silenced, but they're on mute, you have the ability to then see that they have their hand up. In a Zoom meeting, you can mute your voice and or audio. Obviously, that functionality doesn't exist. It would be great for me to be able to look around the room, but I don't have the ability to do that. So here we go. Let's get started. So today I want to talk about how to conduct an efficient and effective electronic meeting under the Open Meetings Act. And the emphasis here is upon the Open Meetings Act. Again, there's a lot of great YouTube videos that will walk you through how to navigate, a Zoom meeting and things of that nature. But I really wanted to focus in on, because we are all, as public employee boards of both retirement systems and healthcare plans, subject to the Open Meetings Act, it's really important that we navigate this new format in light of the Open Meetings Act. So some of the things you need to ask yourself, let's see, my slide's not changing here. All right, one moment. I had this all up and working earlier, and the slide's not advancing. Let's see. There we go. All right. So, I've really divided today's talk between 3 different subheadings. Certainly, we need to review the Open Meetings Act in general, and this will be a review of the Open Meetings Act prior to the governor's recent executive directives and orders to be applied during this time of stay-at-home order. And then we'll talk about how we navigate in light of the executive orders in the Open Meetings Act. How do we navigate that in an electronic meeting format? So let's get started with the Open Meetings Act. As many of you are aware, and we've done a lot of presentations in the past on the Open Meetings Act, the purpose of the Open Meeting Act is to provide that meetings of the public bodies are open to the public, right? And to establish the procedures and guidelines for the conduct of those meetings. So it's real important. There's really just there's a lot of definitions under the statute. There is a great guide to the Open Meetings Act. If you Google it, Michigan Open Meetings Act, there's a great guide that's been put out, a lot of great materials out there on both the Open Meetings Act and the FOIA, the Freedom of Information Act. But just as a reminder, there's 4 definitions I'll touch on briefly. Public body. There was arguments years ago that somehow boards, because we always argued they were distinct and separate from that of the governing body. It's been very well established in the law now that a public body includes a retirement board and or a retiree healthcare board. Meeting's an important definition because there are many times when boards get together or trustees get together, that's not really a meeting, although there is a quorum or certainly enough trustees present at both either a social gathering and or a educational format or things of that nature. So it's really where there is a quorum present, but the quorum is present for the purpose of deliberating towards or rendering a decision on public policy. So when we think of meetings, there are very often times when a quorum isn't met. And so you cancel the meeting for lack of a quorum. But at that point in time, if you've got some vendors available or vendors present in a meeting that want to provide information, that then can become a educational type session, informational session. But because there is not a public body there, the provisions of the there's not a quorum present. It's not really considered a meeting subject to the Open Meetings Act. So while you could certainly keep minutes and follow the rest of the provisions of the Act, if you don't have a quorum, you necessarily don't have to follow those provisions. Closed session is important. Under the Open Meetings Act, it's generally understood that all meetings of a public body at which a quorum is present are to be done in open session with the ability of the public to hear the information being presented in the discussion that takes place. If for any reason you want to, go into closed session, there's limitations under the Act as to when you can go into closed session, and you have to comply with those. You must meet those requirements. We'll talk a little bit about those. And obviously, a meeting is where you are deliberating towards or rendering a decision. And so the definition of decision is important. Decision is, can be a determination, action, vote, a proposal, recommendation, resolution, ordinance, bill, any sort of things where a vote of the members of the public body, the trustees, is going to be required or taken, is considered a decision. Meetings. Under the Open Meetings Act, all meetings of the public body must be open to the public and should be held in a place available to the general public, unless you meet that exception of having the ability to go into closed session. All decisions of the public body are made at a meeting open to the public. And obviously, as I indicated, the Act does not apply to a meeting that is a social or chance gathering or a conference or something of that nature. And so obviously when you're attending a MAPERS conference, even though you may have a quorum of your trustees sitting in an educational session, that certainly does not qualify as a meeting under the Open Meetings Act. Public notice. This is important both in the context of our regular meetings, but certainly important in the context now of having these virtual meetings or conference calls to conduct our meetings during this time of the pandemic. So public notice, where you post it. It's always to be posted at your principal office, and any other locations considered appropriate. Obviously, we'll talk about the governor's executive order at this time when all of our public buildings are closed to the general public, or most of them. It's very difficult to be posting that public notice, so we'll talk about the direction and the guidance the governor has given in that. A meeting shall not be held unless that public notice is given. And so if you fail to give the notice requirements, you do not have the ability to meet. And then we talk about for regular meetings. Your regular meetings are your monthly meetings that most of you adopt a schedule. It's your last meeting of the year for the next year, or the first meeting of the year. But the Act requires that you post within 10 days of at least your first meeting in each calendar year or fiscal year, a public notice with the date, time, and places of your regular meetings. And that's generally under the Open Meetings Act. What is required in a notice is just the date, times, and places of your regular meetings. Many of you have those regular meetings now set up and posted around, so you'll have to pay attention to the now new requirements for public notice as we amend that schedule, because we will be, while the dates and times may not change, the places of your regular meetings for many of you have changed. So that's important. If you change the schedule of your regular meetings, you shall post within 3 days after which the change is made, stating the new dates and times and places. So for those of you changing your regular calendar schedules, as you did in light of the stay-at-home order, you will be required to post that, and how you post that we'll talk about. If you reschedule or schedule special meetings, this comes up very often when boards, even in the normal course, want to schedule a special meeting. You can do so, but you have to provide at least 18 hours notice posting of that. So what's interesting, and a lot of people talk about this very often, while the Open Meetings Act does require a public body to give notice, there is no requirement in the Open Meetings Act that you include an agenda or a specific statement as to the purpose of a meeting. Normally you can conduct at any meeting unless the board's adopted a policy otherwise, that you can conduct any business that would normally come before the board at a meeting. So obviously the governor's executive order has amended some of these provisions and impacted these notice requirements, and we'll discuss that in a little bit here. So closed sessions. The Open Meetings Act, as we've indicated, clearly indicates that you are to conduct all business in the meeting open to the public. There is the ability, provided you meet the specific requirements under the Act, to go into closed session. Some people refer to them as executive sessions. The Act does not use the term executive sessions. I encourage you to use the term closed sessions. That being said, there is a requirement for a 2/3 roll call vote. And so unless you meet the requirements of sections 8A, C, and G, and I'll touch on what those are. Certainly for purposes of retirement systems, 8A and 8C sometimes come into place, and those are on the next slide. We'll talk about that in a moment. But you do need to do a roll call vote. Now, there is no requirement that you do a roll call vote to come out of a closed session, but certainly you need to do a roll call vote to go into closed session. So even if you just need a simple majority vote, meaning you're going into closed session under 8A or 8C, then by all means, you still need to do a roll call vote. You do need to keep a separate set of minutes to be taken, either by your recording secretary. Many larger bodies, the employers use the city clerk, but certainly for retirement systems, your designated secretary, whoever is doing your minutes for the regular session, should take them at a closed session. If it's a matter that you choose not to include staff or something in for a closed session, understand you still need to have someone prepare a set of minutes. What's interesting for those of you who are concerned about how long you have to keep certain records and have adopted disposal schedules, the minutes for a closed session are one of the few areas in the law for public sector pension plans where we can find a clear delineation as to how long you need to keep them and how they're to be kept. So those minutes are needed to be retained for at least a year and a day after the approval of the minutes at the regular meeting in which the closed session was approved. So even though you take a separate set of minutes, those minutes are to be approved as well at a regular meeting. Closed session purposes, as we talked about. 1 and 2 here are the subsections 8A and C that I referenced. There are other basis to go into closed sessions. I did not include them here because they're really not relevant for public sector pension plans or retiree healthcare plans, so I didn't include those. These are really the 5 basic reasons why a retirement board would go into closed session. First is to consider personnel matters. And this is very often disciplinary matters, evaluations, things of that nature for employees and staff is when it is typically utilized, or recording secretary or somebody that the retirement system uses. The key to utilizing this as a purpose for a closed session is the individual that you're going into closed session to discuss must request that you conduct that review, evaluation, disciplinary proceeding in a closed session. If they do not request that you do that in closed session, you are not able to go into closed session. So you should document that the individual has requested the closed session. That does not mean then that you have the ability, since they've requested it, to exclude them from that meeting. They may recuse themselves, but there's no clear guidance in the law as to their participation or your ability to remove them. So keep that in mind as well. Not typical, but sometimes number two here is to the extent that there are some negotiations surrounding the collective bargaining process. If either negotiating party requests a closed hearing, a closed session. This very rarely comes up in my 30 years of working as a pension attorney, but there are instances where employer sponsor may come and need some guidance on some retirement issues that they are currently negotiating with the union, and want some input of the board as to the administration or the provisions that they're looking at with regards to retirement system amendments. If that's requested to be in closed session, you do have the ability to do that in a closed session. To consider the purchase or lease of real property at the time when you've got an option to purchase that is being considered and discussed. Obviously, for business negotiation purposes, you do have the ability to close and go into closed session then. And then certainly to consult with your attorney regarding trial or settlement strategy. Now, I see a lot of boards sometimes deal with this issue in trying to discuss potential litigation. Someone is looking to sue the board, threatening to sue the board, or they have, filed litigation, but there's something that doesn't rise to the level of either trial or settlement strategy, or would somehow have a detrimental impact. So you need to be conscious that the provision regarding threatened litigation or litigation is very clear in that you can go into closed session only regarding true trial or settlement strategy, or if to have the discussion in open session would have a detrimental financial impact on the litigating or settlement position of the body. So it needs to rise to that level. Now, in an instance where someone is threatening litigation and there's concern about what action may be taken and a desire to go into closed session, in some instances, number 5 gives guidance, and that is 5 is to consider material exempt from discussion or disclosure by state or federal statute. If you are in receipt of a written legal opinion, and so legal opinions, the attorney-client privilege does give you the ability to go into a closed session because it is a privileged document and it is exempt from disclosure by state or federal statute. So that applies. This is where also very often our medical records, our determination to consider a medical disability. It's under number 5 that we would go into closed session to protect an individual's right to privacy and medical records. Moving on, minutes. The Act does require that you keep minutes. The Act does not give us great guidance as to what's in minutes. I've seen some boards be able to do minutes of a 2-hour board meeting, and they've done it on a page and a half, 2 pages of typewritten document. The pure requirements under the Act are that you have to have the date, time, place, members present, absent, and any decisions made. So a motion and then the vote on the motion. If you go into closed session, the purpose for going into closed session. I encourage trustees to see that their minutes contain a little bit more than that. Sometimes some people would consider it considerably more than the minimum requirements of the Act. And that's because you are fiduciaries. You are held to a fiduciary standard. It's very important that you document the decisions that you've made, not just the ultimate decision, but the deliberative process. As we all know, we've spoken a lot about fiduciary duty, and it's the due diligence standard and your need to make sure you're well educated, well understood, and that you're making decisions based upon significant enough information that a prudent trustee would have made that decision. And so it's important that that be documented in the minutes and in the record as well. So the next 2 sections are sometimes a little problematic for some boards because minutes, generally get done. The board will receive a copy of the minutes just prior to the next meeting, and then they approve them. Sometimes they have to delay the approval of the minutes. The act, although it's not challenged very often, and I don't see people challenging it or raising the issue, minutes are considered public records. They're open to public inspection and should be available at your office pursuant to Section 4, and they should be available for public inspection not more than 8 business days after the meeting to which they refer. So that means that a draft or a rough draft, proposed draft of minutes should be available within 8 days. If someone were to come in and request those under the Act, you'd have an obligation to be able to provide those. So once they're approved, they should be available not later than 5 business days after the meeting, but it's usually that 8-day requirement that sometimes can be problematic, and boards need to be aware that draft minutes should be made available. And certainly those proposed minutes can be, as rough as the individual's notes, but they should be a little bit more substantive than that. Decisions, there's a presumption under the Act that all decisions of a public body are presumed to have been rendered in compliance with the Open Meetings Act. There is the ability for the Attorney General or the prosecuting attorney for the county in which the public body serves to challenge and commence a civil action. And certainly any person can commence a civil action for breach of the Open Meetings Act. There are requirements. I don't need to spend a lot of time on them here. If you are found to have not complied with the Act, ultimately the decision made at a meeting that was not done in compliance with the Open Meetings Act is rendered void. And so the remedy to that from a practical standpoint is to correct the notice requirements and or the whatever the Open Meetings Act violation was, and to redo whatever the action that is being challenged or was taken at that meeting. There is to be aware of, some penalties under the law for intentional violations. You can be charged with a misdemeanor if you're continuously trying to intentionally violate the Act. Of course, you have to prove the intention, and then there's some civil actions for damages, and those are there. I forgot to mention at the start of this, and many will now be scrambling. I do note that these slides and this presentation is available on the MAPERS website. Michelle downloaded it onto the website, and it's under the materials for today's session. There's also a statement under there that I'll be going through a little bit later. So I'm going to pause there and see if there are any questions that came in. I haven't received any texts from my crew that's monitoring. I see that there's a few Q&As up on the screen.
Michael, we do have one question.
Okay, thank you, Jacqueline. How are you?
I'm well. This is
so
Jacqueline.
Wonderful to have someone talking back to me here.
Can you see me?
Yes. No, actually, you're kind of in the black here.
Interesting.
Yes. So what is the, there you go. Now we see you. You're a little dark in the room there, hiding from the kids, I hope.
I am hiding from everybody in my house.
There you go.
Again, I'm Jacqueline Sobczak from VanOverbeke, Michaud, and Timony. There were a couple of questions that came through and we kind of fielded them. However, there is one pertinent question for right now. Someone asked if closed session meeting minutes must be approved by the board.
Yes, under the Act that they are to be approved by the board. It's written right into the statute.
And then oddly, as you stated that the presentation materials would be on the website, someone asked the question almost at the exact same time. So to answer that question, yes, they will be on the website again.
Michelle has them up this morning. She put them up this morning. So they are there and available for you.
Okay. And then the other question we will save until part 3.
Oh, okay. Well, thank you.
You're welcome.
All right. So in light of the requirements under the Open Meetings Act, and before we even get into the recent executive directives and orders, thought that comes to mind for me is boards have always been able to allow for the participant trustees or member trustees to participate in a meeting via an electronic device. So many of you as boards have adopted policies and procedures providing for a trustee to participate. The law in the state has not been really well settled. And what I mean by that is you will find a lot of different opinions across the state and certainly in many city attorneys, people I've spoken to about exactly what the law does and does not allow. My office has always taken the position that if the board chooses to adopt a policy and allow trustees to participate via an electronic communications device, whether that be by a conference call, video conferencing, FaceTime, or now Zoom or GoToMeeting type formats, that they can be allowed to participate and fully vote in that matter. We've had instances where boards have had to have special meetings to deal with something of an emergency type nature. And in those instances, as long as you provide the proper notice and have the ability for the public to come and participate. So in the past, we've had instances where, staff and telecommunications device, a conference call, phone are available in a room. Public can come, public could participate, listen to the discussion, and you had, pretty much the quorum of the board present on other devices and one or two trustees present in a meeting. It was always our office position that as long as you met all the other requirements of the act and that the public could clearly hear the discussion that was taking place and clearly understand who was speaking and the action taken by the board and the vote and those sort of things, that met the requirements under the act. The difficulty arose when the governor now said that all of the meeting could be conducted via an electronic communication device, and that obviously we could no longer have the public attending a location or a central location, and then obviously the need to change the notice requirements and things of that. So we've had two executive directives from the governor issued thus far, and one on FOIA as well. So three that I will touch on briefly today, but they've certainly helped address what I would otherwise have considered the hurdles to conducting meetings at this time and during this time. So again, it doesn't want to advance. 1 second, here we go. All right, so first executive order 2020-02, the governor issued a statement recognizing the requirements of the Open Meetings Act and indicating that the requirements could be met and satisfied by utilizing either phone, video conferencing, or some other electronic means, provided at least notice of the meeting was given, which was a minimum of 18 hours. And post it on a web page. And that if you were going to have such a meeting, the public had to have the opportunity to participate via an electronic means as well. And so that is really the big significant change with this executive order, was that you had to now allow the public to participate via an electronic means, and you needed to give them clear indication and clear directions on how to elect to participate. And again, keeping in mind that the Open Meetings Act is really intended, and the purpose of the act was to give the public the ability to participate in the meeting process. And so the governor issued this executive order. My office had issued a memo dated March 16th on this executive order. And I think then it was further disseminated by the MAPERS organization as well. And so you should be able to get a copy of that if you have not received one as of yet. There's been a couple other memos issued as well by my office. And I will make sure Michelle has a copy of those, and those are posted to the MAPERS website. I do believe they are already now. And they'll let me know the next time I go to ask questions what the status of that is. So. Executive Order 2020-15 really provided a lot more further guidance and clarification around the Open Meetings Act and what needed to be done during this time. And it really was more about the notice requirements, was probably the most significant piece of that executive director. You now needed to give a reason or an explanation as to why the board was meeting electronically. Keeping in mind, in the past, you've not needed to post an agenda. You just needed to post that you're having a meeting, the date and time and location. Now, if you're going to have a meeting, you need to indicate the reason. And that reason as to why you're meeting electronically. And certainly the reason you're meeting electronically can be a regular meeting to conduct normal business, but you're meeting to obviously further comply with the directive of the governor and to minimize, obviously, the impact and the growth of the COVID virus. So that should be referenced in there. So your notice requirement now needs to include a statement as to why you're meeting electronically. And you now need to have very clear, detailed procedures by which the public can participate in the meeting electronically, including a telephone number, an internet address, a link, some form of way to communicate. And we'll talk about some of the ways to do that, but you have to allow for the public to freely participate electronically. And freely, I will qualify that. Obviously, the public has always been allowed to freely participate in a meeting held at a location, provided they're not breaching the piece of the meeting, right? And certainly any violation of that, even in this new forum, there are ways to remedy that, to address that. So there needs to be procedures in your notice by which persons can contact the board to provide input or ask questions on any business. Now, that could certainly be by way of indicating to people they have the ability through the meeting to use the chat feature if it's available. And someone should be monitoring then the chat icon, and whether that's a staff person or not, someone should be monitoring to see if there are questions that are arising through the meeting. The chair can then decide when to recognize those questions and accept those. But certainly you need to have now a portion of your agenda for public comment and to make sure there is that process. In addition to that, or as well, you can certainly provide the ability of members of the public to be able to contact, send emails to a designated representative of the board or staff to be able to address anything that would normally come before the board at the meeting. And then certainly procedures by which persons with disabilities can participate. That executive order was set to expire, has since been extended. We have provided a sample notice as well as a memorandum on this executive order back in March. And again, that will be made available to you. And then the last executive order really dealt with FOIA. As you know, under the FOIA Act, there are very strict timelines in which we have to respond to FOIA requests and then to provide documents that are requested. The FOIA Act really just extended those time requirements and recognized that if there's a need, obviously for public inspection, that's changed. You can defer that portion of a request until after the order expires. And as well as then if you need to go physically to an office to retrieve records, you can extend the amount of time necessary to respond to that FOIA request. So again, this is another executive order that we've provided a memorandum on, and that would be made available to you as well if you've not received a copy of it. So in light of all of that, how now is best to go through and conduct this remote meeting, and the considerations of how you would do so in light of the Open Meetings Act. I'm going to pause real quick before we get started here, see if there's any other new questions on the executive orders. I saw the banner and the flasher going up there a few times, and I see Jacqueline is back.
Hi, I just came back so you weren't lonely. There were no questions.
Thank you. Appreciate that. Oh, great. Great. All right. And do you know, can you check with Michelle to see if, I know we distributed those memorandums to her. Can you check with her and verify that those have been posted up on the MAPERS website and where they are?
Yes, on the chat section.
Here she comes.
Yes, those are posted on the MAPERS website on the latest news section.
Okay, great. Thank you so much, Michelle. All right, let's move on. Thanks, Jacqueline. See you in a little bit. All right, so conducting a remote meeting. You have some initial considerations. First, what form do you want to conduct this meeting in? You certainly have the ability to do this sort of electronic meeting, what I would call old school, right? You can do pure conference call. Have a conference call number and allow for individuals to call in. does not need to be done on a computer or virtual type meeting. There are some difficulties with that, and that is that you have to allow for the public to be able to participate in that meeting. And so you lose the ability to readily identify who's in the call or see, numbers or things in the call. And we'll talk about the need for people to identify themselves, but it may be difficult in that form, and certainly your ability to mute other callers. Now, that being said, some of the more sophisticated conference call resources do allow for the host of the conference call to log into a computer screen where they can monitor what is taking place. And so certainly you can do that. I did participate in a conference call meeting last week. I've done kind of all the forums at this point with the various boards over the last 2 months. And I will tell you that the meeting went surprisingly much smoother than I thought it would. But it is a little bit more difficult to navigate that process. And so many boards are looking at doing more of the new virtual type meetings, either through Zoom, GoToMeeting. There's lots of different forms to do that, but certainly deciding on the form you want to use. And certainly to do so, it would make sense to contact your plan sponsor to see if your plan sponsor, in light of the employer, the city, the township, the county, to see what they've subscribed to, what is available to them, and what their recommendation is. Sometimes the tech people at the city or the township, county have already vetted a few different companies and have some mediums for you. So certainly it's a great place to start. Or if you don't have the ability to do that, to maybe contact one or two of your service providers. I will tell you, some of the service providers have subscribed to the services and have no problem then setting up a meeting for the board in that sort of format as well. And certainly you have the ability to go and take a subscription if you need to do that, to be able to provide that, or take on the free venue. The problem with most of the free is the limited time period, and most boards and entities will last longer than 40 minutes, and/or you want to make sure that you're not capped at the number of people that can participate. Certainly you understand the number of people. I had a meeting last week where there was actually last month where there was a limitation of the number of people that could participate in a conference call. And so there was literally a trustee or two that could not get into the call. And then as well, the question arises then, what about the public? That's not a meeting that's truly open to the public because there's a cap. And so you need to correct those deficiencies and make sure that they don't exist. The next consideration is the stakeholder needs. What resources are available to trustees and staff? Does every trustee have a computer at home? And in most instances, everyone has today a computer and the resources available, but you want to make sure what those are. You need to maybe check with your service providers as to what resources or what issues that they would like to see resolved. Are they looking to do screen sharing? Is there information that, there's a certain forum or type of platform that would work well for them in terms of providing information to the board? And then certainly the timelines for your meetings, amending your meetings, certainly getting your agenda packets out, things of that nature. What are the other needs of the board for a typical meeting, and how are those changed in light of this new form that we're meeting in? And then finally, board policies. Some of your board policies may be very restrictive as to how meetings can be conducted. You certainly want to review your board policies, make sure you're doing your best to comply with those policies. Certainly timing issues, things of that nature as well. If you have disability retirements, we will talk about how to conduct a closed session in this new forum. But certainly, what are the timelines for administrative appeals? What kind of notice do you need to give? We got to give notice of special meetings, things of that nature. So review your board policies and be aware of how those may be impacted by this new reality for us. I want to spend a few moments and really talk about the role of the chair. And I think this is important, not just for chairs to hear, but all trustees to hear, because it trustees should have an understanding of the importance of the role of the chair, certainly in appointing a chair and electing a chair, but also to be able to recognize that the chair has a more assertive, more important role in running a meeting. Sometimes, my 30 years of practice, I've seen a lot of really great chairs. I've seen some chairs that could use a little work on their ability to run meetings. But I've also seen very often that trustees not being respectful of the difficult role of a chair. And so that's really important. I have witnessed and observed in the last 2 months how vital and how important the role of the chair has become in this new type of virtual meeting reality and/or even conference call reality that we're facing, and being able to navigate from a remote location all the different trustees as well as members of the public and staff. And so, the chairperson does have a very difficult role, but is still the person through which all discussion is supposed to take place, and is still responsible for controlling the order and the structure of the meeting and the information being discussed. The chair also has the responsibility to make sure not only that the conduct of the meeting is reasonable, but that the meeting is moving along. In this new forum, I do find that very often, and I've witnessed the extremes, but some boards that the meeting probably lasted an hour longer than it otherwise needed to, because the chair didn't feel that they were able to control the meeting as they otherwise would have at a regular meeting. So I know most of you are now thinking, geez, he participated in my meeting. No, this is nothing specific to any one board. So please don't take it personal. So let's talk about the role of the chair. The chairperson's goals are the same whether we're talking about a virtual meeting, conference call, or an actual board meeting, right? The chair's role always is to coordinate and focus the board's effort to keep the discussion on the subject matter that's best in front of the board, to choose the best structure for giving clarification or information, to get clarification of vague statements. Sometimes trustees make a statement that it's hard to give, hard for people to really understand what their point is. And sometimes a chair recognizing that can help clarify those vague statements. I see we have a question coming in. I know I just got my remote text that there's a question on point. So Jacqueline, are you there? She probably wasn't prepared for me to go to this question so quickly.
There is a question. I believe that you're discussing the one in the Q&A, and they were asking for hosting, how they would host final presentations on Zoom.
Okay. So a finals, yes. So and that is right. How do you do a finals presentation? And the reason that comes up is because we know that at most public board meetings, when you do a finals presentation, you know who's in the room. And so when you have 2 vendors, right, or 3 vendors that you're doing their interviews, usually one group is in and the other 2 groups are removed. And then they rotate in and out. And so in a board meeting, because we're sitting there together, we know who's in the room and who's not in the room. Under the Open Meetings Act, in a finals presentation, we do not have the ability to exclude another vendor from participating. You may choose then to disqualify them because you feel that they're trying to take an unfair advantage. And I'm talking about a finals presentation where we're really not in contract negotiation. One could argue it's a contract negotiation, but you're really in a finals presentation to gather information about a service provider. And so it is a courtesy amongst members of different investment firms or professionals that they don't choose to sit in that meeting. But if it's a full board, there is no basis under the Open Meetings Act. If you go in the ability to go into closed session, there is no ability to go into closed session. So members of the public are allowed to be there. If members of the public are allowed to be in a finals presentation, so are the other vendors. That being said, one of the nice things about a virtual meeting platform is to ask, as a courtesy, that those other vendors recuse themselves from the meeting. But if they choose not to, how the board elects to move forward is up to the board. But there is no ability to necessarily exclude and you know, and I've not seen any case law on it or anything to the contrary, but to exclude members of the public from a finals presentation or then members from a competing vendor.
Thank you, Michael.
You're welcome. And I certainly, you know, for those of you who have comments on a statement like that or observations or things that you've done, you have the ability to use the chat or the Q&A to do that, and we can certainly bring that forward. You know, I've always enjoyed that open dialogue and communication with you, so don't hesitate to do that. So obviously, the role of the chair is to give trustees clear behavioral expectations. There are very few boards that I've encountered an issue of that kind of contentious behavior where you really need to address behavioral expectations amongst trustees, certainly sometimes with the public, but you know, that's really not an issue, but certainly that is part of the role of the chair, is to let people know when they're speaking out of turn and or when they're speaking disrespectfully. And along those lines is the idea that we certainly need to protect, and the role of the chair is minority opinion. That's so important. That's part of the basis of the rules of parliamentary procedure, is respect for is to honor the rule of the majority with respect to the minority. And so it's very important that the chair, even if the chair is on board with the majority of the board, that the minority gets an opportunity to speak and share their opinions, and then obviously reduce needless conflicts. So calling the meeting order and public participation. At the end of this, and certainly posted to the MAPERS website, is an actual scripted opening statement for the chair, and we'll talk about that. But you know, the chair, obviously in this remote meeting forum, should call the meeting to order as they always would, state the time and title of the meeting as listed in the public notice on the agenda. It is very important, especially at these remote meetings, to recognize which trustees are present, service providers are participating in the meeting. If you typically call for a roll call for attendance, where participants affirm their presence, you can do that. You can, as well as a chair, you know, if you're in a forum, a virtual meeting where you can literally see the members present, you can note who's present, so you don't necessarily need to do the roll call. Those things are not set forth in the law. What is required under the Open Meetings Act is it be very clear which trustees are present and those that are not present. In many of these forums, you will have instances where you have some trustees participating in a virtual meeting with use of their video camera, so you can see them on their mobile device. And others may call into the meeting, so you have the ability to do that. And certainly, if you're going to do a virtual meeting, I believe under the Open Meetings Act, you need to make that meeting available, and all the forums allow for it, for people to participate in a non-video format where they can call in and use it more in the traditional role of a conference call and use a mobile device for that as well. You can call for the role and the attendance of the trustees, certainly recognize your vendors that are there. You cannot require a member of the public to provide his or her name to participate in viewing the meeting. I had a virtual meeting the other day. We were able to identify everybody on the call, but there was one phone number that showed up, no video, as participating in the meeting. The person chose not to identify themselves and frankly never did through the entire meeting. And so the meeting was over, and there was obviously someone who participated in listening to that meeting. They never spoke. And nobody knows who was there. That is a meeting in accordance with the Open Meetings Act. Now, if the individual chose to speak during public participation, it is allowable for a board to have somebody to identify themselves if they're going to provide comment and speak, so that their comments can be included and their appearance can be reflected in the minutes. But otherwise, you do not have the ability to require everybody on the call to identify themselves. That being said, you do have the ability to mute that person from speaking. Certainly at public comment, you'd have to unmute that and allow a person to provide that public comment, but you do have the ability to mute that. Yeah, I think it's important then to ask, the chair should ask as part of that Oh, we went too fast here. The chair should ask if there is members of the public and if they choose and want to speak during the public comment section of the agenda. Now, very often in practice, we know that there are sometimes members of the public that are there to speak on a very specific item that's on the agenda. Now, in most city councils and larger boards, it's very hard to allow for public comment on every agenda item. And so the Open Meetings Act does not require you to do that. That being said, there are a lot of boards, especially retirement boards, that will recognize that if there is something on the agenda, sometimes it's a specific agenda item that there are members or a member or somebody from the employer sponsor or union that want to speak on that item. I think that's a great concession to allow for people to speak on specific agenda items, as long as it's not disrupting the flow of the meeting rather than requiring them to speak on public comment. And very often the frustration is if public comment is the last item on the agenda, and this is an item that's coming up that they really want to speak on prior to the end of your agenda, then they really don't have an opportunity to provide you their thoughts. And so I've always recommended that public comment be at the beginning of an agenda, and still recommend that. But that's certainly the ability to use in a virtual meeting the icon for someone raising their hand. There we are on the screen, raising their hand, and or the chat and someone monitoring the chat for those people that would like to speak can certainly be done. I think one of the great practices for a chair and or administrator through an agenda has always been, and this is part of my regular presentation on how to conduct efficient, effective meetings, is what I call an orientation speech. And that orientation speech should be on every item on the agenda. So when an item is on the agenda, it is on there for a reason. Well, what is it on there for? And so the next item on the agenda is an easy one, is a disability, is the disability retirement of so-and-so. Provide a comprehensive information rather than just leaving it at that. A good chair or a good administrator would say, you may recall this application was submitted to the board back 2 months ago. We've sent the individual to Dr. So-and-so. They've had an examination. We also received their medical reports. So a little bit of the history of why we're at, why this on the agenda. And then perhaps a review of the plan provisions that are applicable to that instance, and then be able to focus the board on the reason why an item is on the agenda and what it is we are attempting to do or how we're going to proceed today for this agenda item to arrive then at a conclusion. That gives everybody a great background, some good due diligence information to render a decision, gets rid of a lot of unnecessary extraneous discussion because everyone now knows why this item is on the agenda, and what action and what it is that we're looking for the board to do. If it's then the review of an actuarial report, an audit, a budget issue, those sort of things is really important. So I think an orientation speech and someone being familiar with every item on the agenda and giving everyone guidance as why and what it is the potential outcome is real important. I had one board previously that the cover sheet to every agenda item was a little bit of this orientation speech or the motion that was being requested or sought after. Attached is the bills from so-and-so. And so suggested motion would be listed on that. And the motion provided for the payment of the bills from so-and-so and everything else. So you have the ability to do that. I think in this new forum, because it's very difficult to necessarily see the consensus, these orientation speeches are important. I do have a draft, and I'm going to read it through to you, of an orientation speech that I think is very important for a chair and or who's ever overseeing a meeting to do in this virtual reality world that we're in. And so I'm going to read that. MAPERS has posted it, so you get an idea of what I'm talking about, to the MAPERS website. And you'll see that many of the issues that we're going to talk about will then break down as we go through this discussion here. Boy, how time flies. All right. You should have an orientation speech as a chair that would sound something like, and be scripted something like this. I hereby call to order this May 1st, 2020 regular meeting of the Board of Trustees of the City of Maples Employees Retirement System. The time is now 10:57. I'm obviously going to go a little longer than an hour, and I apologize for that. So this is a regular meeting of the board, and it is being held electronically, consistent with and in accordance with the governor's executive orders for the purpose of minimizing the potential spread of COVID-19 coronavirus. In an effort to avoid excess background noise and potential microphone feedback, please mute your microphone when you're not speaking. The host of the meeting can mute you, but then you can't unmute yourself when you would like to speak. So please mute yourself. You can mute yourself by clicking on the microphone icon at the bottom of the left-hand corner of your screen or elsewhere, depending on the type of forum you're using, platform. Please note that this meeting is being recorded. I think it's very important that, and one of the nice things about these new virtual formats and platforms is you can record them. So if you're going to record them, you should let people know. Please note this meeting is being recorded. The purpose of the recording is to assist the recording secretary in transcribing today's minutes. Once those minutes are approved by the board, then the recording will be deleted. Now, you may have different procedures, different guidelines. You may record all meetings and keep those, keeping in mind that as long as you have a recording of a meeting, it is subject to the FOIA, Freedom of Information Act. You still need to create a written set of minutes. The recording is not the official set of minutes. It's the written document. Many boards who use recordings at their regular meetings record them, and then once the minutes for that meeting are approved, then they destroy the recording. But I think it's important to remind trustees that you are going to be recording the meeting as well, because sometimes when you don't see a recorder on the table, there's some, if there's no other members of the public present, as we all know, trustees tend to take sidebars about personal things and say things that they wouldn't necessarily want out in the real world about their personal life or personal opinions on things. Those are not really part of the official minutes. They may be statements made during a recess of the meeting. They may be statements made at the start, prior to the start of the meeting or after. So you certainly want to make sure everyone's aware that whatever is taking place is being recorded and what you will do with that recording. So in terms of then taking the roll, it is noted that the following trustees, staff, and service providers are present. And you could state them if you can see them in the virtual format. And the following are absent if you do know a couple of trustees are absent. If you typically then take a motion to excuse certain trustees, you can do so at that time. If not, you typically do a roll call. The chair would say, I ask the retirement administrator, recording secretary to take the roll. And so the roll would be taken. After that, you would continue. I also see that there are several other individuals that are also present with us this morning. The Open Meetings Act does not require that an individual identify themselves in order to attend a public meeting. If you would like your attendance to be noted by the board and reflected in the minutes, I would ask that you identify yourself at this time, especially if you've done a roll call and you don't know who's there. You can certainly ask that people identify themselves, but you should let them know they don't have to. And then further, when we come to public comment on the agenda, if you choose to address the board, we will ask that you identify yourself at that time. And so if you mute all the non-identified callers, certainly you would need to make sure that someone unmutes them for the public comment portion of your agenda. I also note that it is important that we accurately reflect any actions taken by the board at this morning's meetings. Historically, most actions taken by the board are unanimous. Accordingly, it is very important that trustees that desire to vote no or abstain from any motion on the floor fully indicate as such when the vote is called. I will proceed with an understanding that all trustees are in support of a motion unless I specifically hear otherwise. In the event anyone votes no or abstains, I will call for a roll call vote. I would ask that anyone making or supporting the motion state their name for the record. We're going to really break that down a little more because one of the things the governor recommended in her executive directive was that all votes be taken by roll call vote. I understand that when you get a lot of yays and nays and things of that nature for most of the actions for most of the clients that I participate in the meetings, most decisions are unanimous. And so I don't think you need to add that extra burden to a meeting, but you certainly should do a roll call vote the minute any trustee abstains or votes no. And so then you would go on with your statement. Are there any questions or concern? You'd pause, and then let's get started in the first order of business is. So that's a good example of a opening statement for a chair and or the administrator could certainly take on some of the things that we're going to talk about here briefly. So moving along, motion practice. Typically at a regular meeting, it's, you raise your hand, you just motion and you make it, and the chair can readily identify who's making that motion. In this remote meeting forum, you need to really be cognizant that when you make a motion, you should state your name. So motion by VanOverbeke to such and such, and then, support by Misho. So you should state your name prior to stating a motion, and certainly in your support, you should state that. And then a roll call obviously should be taken if anyone votes no or abstains. And so roll call votes. As you noticed in my sample opening statement, the governor has indicated that, it is suggested that only roll call votes be taken on all board action. I believe from a policy standpoint, rules of procedure, that's not necessarily required. What is required is that it be very clear for the public who's participating in the meeting to fully understand how people are voting and who's voting in favor and or against something. So again, if you take a roll call vote, if you call the question, motion by, support by, to do X, to approve the minutes, all in favor of the motion, say aye, and you hear an aye. You don't need to count those. Any opposed, no. You get no no's. Any abstentions, no. You can, from a policy standpoint, my position would be that you can treat that as a unanimous decision. If, however, again, any one trustee votes no or objects or voices that, and you want to make sure they all understand that that's very important, that if that's their position, they do that, then you would certainly do a roll call vote. And obviously, we recognize the Open Meetings Act here for closed session. Closed sessions. So, there are many instances still today where public boards need to go into closed session. How to navigate that? The governor's executive directives have not given any guidance and changed anything with regards to how we conduct closed sessions. So there's some logistical concerns. When do you do that? Do you do that at the middle, the end, the start of a meeting? And how do you do that? A couple of options for you. One, and I recently did one with one of our plans, they literally did 2 Zoom meetings. They had one set up that was made public, posted in compliance with the Open Meetings Act and all the new guidelines. And then they had another one that they invited only the members of the board. So they opened their meeting, their regular public meeting, as they always did, took care of some preliminary business, then did a motion to go into closed session, did a roll call vote to go into closed session, which was approved. And then they all signed off that Zoom meeting and then logged into the separate meeting. Now, this board was able to have a staff member that stayed in that Zoom meeting in case any members of the public came in to advise them that the board was in closed session. So the board conducted their closed session in the other meeting, concluded that, and then all came back and joined the one that had remained open. You do have the ability, if you don't have a staff member even to stay there, I've prepared these slides in a PowerPoint format, but you can certainly prepare papers. You could literally have a slide like this that went up in your meeting, because you can share screen, that literally said the board is in closed session, will return shortly, and then everyone could depart to another meeting. I've had boards that have done closed sessions and done that through a conference call. You certainly can do that as well. The key and the difficulty in navigating, no matter what you do, is that whatever action you take must be taken in open session. So while you can have discussions in closed session, review medical reports, receive a legal opinion, whatever action you take has to come back into your regular meeting. And so scheduling those as something separate is from a navigating standpoint, is a little more difficult to do, but it's certainly very easy to do it in this manner, where you either post a screen and set up a different. Now, for those of you who've gotten a little bit more comfortable and have subscribed to the Zoom forum or the GoToMeeting forums, there is the ability to do breakout groups, where you can literally break a group of people out into a separate meeting. That's another option for a closed session, where you could break out solely the the host of the meeting can break out just those trustees into a separate meeting. That being said, I do encourage you to speak to your legal counsel to make sure you navigate that. But if you have business that is very important during this difficult time, that needs to be taken care of in closed session, by all means, there are ways to do that, and you certainly can do that. Meeting minutes, you have to take meeting minutes as you always have. And so, you know, this is pretty standard. Who, what, when, where, and why, right? What were you thinking? Why were you there? Where was the meeting? How long did it last? So that should be reflected in the meeting, and you should have your minutes prepared and approved by the board of any meeting you held in this format. You should also be aware that, you know, sometimes there's technical difficulties. If for any reason you are no longer able to conduct your meeting in the method outlined in your notice, meaning you have to change your login, is probably the one difficulty we've encountered. A different login was required, then you have to stop the meeting. You have to make sure, again, consistent with the purpose of the Open Meetings Act, that you have the ability to bring everybody in and it is open to the public. And so if for any reason you have some technical difficulties that changes any of the how, where, why, what time, and the form and the way the public can participate, then you must repost notice and do that at least 18 hours before that meeting. So before we get into questions, there's a couple other notes I had made as I had been preparing for this. I want to make sure I've covered them. Share screen. Share screen is a great option. I'm sharing my screen with you now in this forum. There is the ability to share a screen in the format of Zoom meetings, GoToMeetings, you know, any of those other forums. There's the ability to share a screen. I would, and typically it's only the host that can share a screen. So to the extent you have a vendor, an actuary, a money manager, your investment consultant that has a presentation report, you can use the Share To feature. And in those smaller meetings, even though they're open to the public, I would encourage you to allow your legal counsel as well as your investment consultant to be co-hosts of a meeting so that they get that flexibility and they can move within that forum or help you guide through some of the difficulties. We're doing a lot more of these than most boards, so maybe we can help you navigate that. So certainly including more than one person as a host is helpful in that instance, and certainly using the share screen feature. As an administrator or board chair, you can also use this share screen feature to put your agenda packet up. You can download the entire PDF agenda packet and have that. The only concern you have to be aware of if you're going to use the share screen feature is that it is a meeting open to the public, and whatever goes up on that share screen then becomes a public document. So you want to be very careful that in an open meeting you are not sharing a written legal report that is legal opinion that's subject to the attorney-client privilege or medical reports or things of that nature. So whatever you use in that share screen should be confidential information. If you're scheduling a meeting, you should talk to your vendors and find out from them what their needs are for the meeting. Oh, sorry, I just pushed the button there. Let me go back to that. You should make sure you talk to your vendors and service providers ahead of a meeting to determine what their needs are or participation needs. I think you should have trustees familiarize themselves with the meeting format prior to the scheduled meeting. You can offer as I said earlier, a training meeting, an ad hoc mock meeting. Most administrators or chairs know the sophistication of individual trustees. It may make sense to contact one trustee who you know technically has problems in this kind of a meeting form, isn't necessarily real good with computers and things of that nature, and schedule a one-on-one session meeting with them so that they can navigate it and freely work through that. You need to be aware that each hardware takes some of these forms and makes the virtual meeting look differently. What I mean by that is how a Zoom meeting looks and operates under a PC, a Windows versus Mac, a tablet, a Chromebook, an iPad, all look very different, and different features are enabled and available. So you want to make sure you're aware of that. Whatever your virtual interface is, that you're aware of that it will look different. So if you prepare for a meeting on one device and then at the very last minute choose to use a different device for that meeting, it can result in a very different experience for you. So through a meeting, someone should be monitoring that chat box. So while that chat feature is there, you want to make sure you are not violating the Open Meetings Act by having private discussions amongst trustees. Also recognize that your ability to send text back and forth with other trustees, if you're discussing items on the agenda, that's considered a sidebar private discussion that is in violation of the Open Meetings Act. So you want to make sure you're not using chat or your mobile device to violate that. Certainly you can encourage, there's lots of great tutorials on YouTube. You know, you can Google them to really understand whatever your virtual interface is, whatever the browser is, whether you're using, again, Zoom, GoToMeeting, some of those others. There's great YouTube videos. I encourage you to do that. Consent agendas. If you have never used a consent agenda, I would encourage you to have some discussion around that. I think it's another way of really navigating these virtual meetings a little quickly. Consent agendas are usually things that are in the normal course that you have very little discussion on and that get approved by the majority of the board in every instance, or certainly in unanimous decisions of the board. And sometimes consent agendas can be things such as minutes, although sometimes minutes are not included, but certainly payment of bills, routine retirements, things of that nature. And what's nice with the consent agenda is they're approved in mass. So one action, one motion approves all the items on a consent agenda. So if you've never used a consent agenda, I encourage you to perhaps explore that during this time. It's certainly an option. And then finally, regular meetings. If you have now regular meetings and you're planning the next 3 meetings of the board and or subcommittees or committees that are also subject to the Open Meetings Act, you can get a regular meeting ID. For those of you who are participating in the webinar today, you had to pre-register. You then got an email that gave you a meeting ID. That meeting ID is unique to this webinar. Meetings also will then have a unique meeting ID. However, you can have reoccurring meeting IDs so that you post a notice, if you're going to post a notice for a Zoom meeting as your regular board meeting, use an ID and set up a meeting ID for that you can use that same notice for your next few meetings. So you can post that so you're not having to change that. And it's easier then for trustees to find that meeting because they can look it up and they find it, and oh, there it is, and they go right into it. So certainly you can have a common ID. So with that, I'm going to open up for questions. Jacqueline, are you there?
I am here.
Great.
However, the host needs to allow my video to begin. But I will continue until, here we go. Thank you.
Okay.
There were about 4 questions.
Okay.
One of them is a follow-up from the closed session meeting question.
Yes.
When they approve the closed session meeting minutes, are they in closed or open session?
They're approving the minutes, right, in open session. That does not mean that they're subject then to, some people believe that if you approve something in an open meeting, that then whatever it is you approved is now subject to the FOIA. And that's not true. We approve legal opinions, right? The board can acknowledge receipt of a legal opinion as a motion, and that legal opinion be subject to the attorney-client privilege. So it doesn't necessarily automatically become. So yes, you would approve under your regular minutes, you would approve the minutes of the regular meeting held such and such, and then either as the same motion or a separate motion, then you would have a motion to approve the minutes from the closed session held such and such. You do not need to do that in closed session. That does not mean then that because they're closed session minutes, somehow you've made them subject to the FOIA, but you would approve them in the regular open meeting. Just
Okay.
like you took action in the open meeting.
Okay. And then there were there was a question about the meeting packet materials. Would you put that on the screen for public view? For example, investment performance, actuarial reports, and invoices.
Well, actuarial reports, right, we all know are subject to the Open Meetings Act. I'm sorry, subject to the Freedom of Information Act, FOIA. So if someone requests a copy, I'd provide those. My investment consultant report unless I hear from my consultant otherwise, unless he's identified some things in his report that are confidential because they're proprietary, they meet the requirements of the FOIA to be considered exempt from disclosure. Most investment consultant reports are public documents. Someone can FOIA them. So depending on how the board feels about that, I don't see a reason why you would necessarily not want to include them in that forum. Most boards have zero participation by the public in a meeting, and they may in this instance, but I would see no reason why we'd not want to do that. There are instances where those certainly documents will need to be sent separately via email, and I would not post. So I just want to be aware of what's in that agenda packet. If not, you could certainly just post the agenda if that's what you're most comfortable with, where the agenda is to share screen. And so that's the roadmap and everybody looks elsewhere. I do note that, many of these virtual meetings where they've not used the share screen for the agenda packet, most trustees are then working with two different computers, a desktop, a mobile device, an iPad, so that they have those documents up. It's very difficult for trustees to navigate all of that on one interface, one piece of hardware.
And then another question came in was regarding abstentions for voting. Typically, they're not asked for. So would you recommend that the boards ask for those on virtual meetings?
No, I would note that as typical of any meeting, if trustees have a clear understanding that if they wish to abstain from a vote, they have to voice that at the time a motion is made, right? Because you're right, typically it's all in favor, any opposed, and then we move on. If a trustee chooses to abstain, generally a trustee will put their hand up and say, I abstain. So I think the opening statement, I kind of read through my draft of one, should indicate that if you wish to abstain, you need to voice that, but otherwise, I do not believe you need to ask if there's any abstentions. I know when I read through my motion call, I included that, but you don't necessarily need to.
Thank you. And the last question, how do you track people joining late or leaving early if they are only calling in and not on the live video portion?
If you're using this virtual forum, even with Zoom, and you hit the participant screen, even if someone is participating in the meeting via a telephone and they're strictly using the conference call, their phone number will show up. And so you will know if they leave the meeting. If it is a trustee, right, you should, you need to identify every trustee and who they are and where they're at. And if you look at the screen, you can see I'm talking right now, by the way. So you see a little green box around me. When Jacqueline talks, you'll see a green box go around. So that helps identify who's speaking. I don't know if you've noticed that feature. You'll also, if you hit the drop-down screen that's labeled participants, you will see all the participants in a meeting. You'll also see, and I do note this, a little microphone next to each person in a meeting format. We don't necessarily have that in this format. And you can't do the participants. I don't believe as a participant, you can see all the other participants. So, but typically in a meeting format, you can see them, and you can see when someone is speaking, the microphone has a little meter in it that goes up and down. That's helpful if you're getting a lot of background noise and feedback and you want to mute a voice or mute somebody. But at the beginning of the meeting, you should identify all the numbers that are trustees and or service providers. And then to the extent then that they drop off, that should be noticed. So it's helpful to have someone who monitors that, but otherwise you won't know. Now, if they're not on video screen, can't catch people sleeping, can't guarantee you that, but certainly you can monitor that. And whether it's members of the public coming or going, that's really not an important thing to know. Hopefully that answers that question.
It did. Another one came in, so it's not the last one.
Okay.
Question regarding closed session. While discussing appeals, even though names are not used, do you still have to go into closed session? For example, if only member IDs are used.
Right. So, and I'm assuming then this is a discussion about a disability, right? If we're doing that. There is no requirement under the law to go into a closed session to discuss a disability retirement. And in fact, session, and that is one of the criteria under the Open Meetings Act. So if you're, and the only reason you go into closed session is because you're going to discuss the details of a medical report, and it's going to identify an individual. Now, some boards use an identifier that cannot be tracked back to an individual. However, ultimately, a board needs to grant a disability. So if you've only got one disability coming before the board in the course of a year, right, and you're ultimately going to put that person on a disability retirement, the fact that you discuss the details of a medical report in an open session, but use an identifier mark, I still think you're running into some issues of you can identify exactly who that individual is. That being said, if you're a very large state board or a very large county board and you've got a lot of disabilities going through, you can certainly use an identifier to discuss some of the content of a medical report, not necessarily go into closed session. I'd really want to review the circumstances of that. But I have had many instances where the board receives a copy of the medical report. There's also an additional form that is a questionnaire asked of the medical director or medical committee, specifically indicating whether or not they find the applicant is totally and permanently disabled from further performance duty in the service of the city, and they check the boxes. If the board doesn't feel a need to discuss the details of that medical report and things that are confidential, the fact that an individual has applied for a disability retirement is not protected. It's the details sometimes within those reports. So I don't think a board needs to go into closed session to approve a disability retirement. So all of that said, there are instances where an individual, a board, can review a medical report that's been provided to them, the decision of the medical director, not have any questions, not feel the need to discuss it, and you have a board then that will approve the disability retirement with never having to go into closed session. If, however, you want to get into the weeds and the details of the medical opinion because there's some things that seem inconsistent, you're questioning whether the doctor reviewed things, you want to discuss it with other trustees, you don't understand, there seems to be some inconsistencies, you want to have a hearing with the individual, you want to ask them questions, there's issues of duty causation, then certainly a closed session. But it's not mandated in every instance.
The attendee was referring to benefit eligibility of appeals. No medical information is discussed. So I believe you answered that, but.
Yeah, benefit eligibility on appeals, I don't believe you necessarily need to go into closed session for.
Thank you, and that concludes the questions.
Okay, for those of you, I still see we have 47 participants on. Really miss all you guys. I really appreciate you participating today. My very first webinar, so you walked me through my very first sitting in a room talking to myself. I hope it was informative. If you have any personal questions, comments, certainly share them either here, chat, or my email is available to you. Would love to give, would love some insight, some things you would have done differently. I suspect this may not be my last webinar, but certainly appreciate evaluations and feedback and guidance. What I could have spent a little bit more time on. As always, for many of you, I recognize names, and I've pulled up the participant slide here and looking who's here. Many of you have participated in my Sunday workshops and some of my other stuff. So as you know, I always love your feedback. I love to know what's working, not working, what you'd like me to spend more time on. I really appreciate you taking time out today. I hope you're all safe and healthy. And I look forward, I'm going to get choked up. I look forward to seeing you all soon. God bless. I see we had a couple questions come in. Are we signing off, Michelle? Yes, probably.
They're just thanking us for the webinar.
Okay.